It may be possible, even if you want to take the whole of your 30 minutes, to complete you before we stop for lunch, if that's what you'd like to do.
Yes, that would probably be very helpful all round.
I'm not putting you under any pressure.
No,
You've
indeed.
got 30 minutes, even if you overrun.
Thank you. Well, I'm Pete Weatherby, and I am here representing 73 individuals who are either core participants or those who are awaiting that status. They are a mixture of people from the tower and from the walkways. Some of them are bereaved, some of them are survivors, some of them are displaced residents, and of course some of them are in each of those categories. As you've been told, representatives of the victim core participants have used our time usefully in terms of taking the inquiry's prompt to try to avoid repetition. We've taken that seriously. And indeed, as you know, many of us have considerable experience of doing this in previous proceedings. And therefore, I'm the appointed person to deal mainly with disclosure, which I will come on to after I've made some preliminary comments, if I may. I also like to make clear publicly that I've spoken to two of your leading counsel, and I view that as a particularly important part of the whole process, to keep a dialogue going between all core participants and your inquiry team. Also, within the families and individuals' representatives, we are actively discussing ways of combining to deal with future parts of the inquiry in the most efficient way possible. Plainly, no one has a bigger stake in the success of both the criminal investigations and this inquiry than those who've lost family members and friends, the injured, the survivors, those who've lost their homes and lost their communities. On behalf of all of those that I represent, I make clear that all of my representations to you today and going forward will have that well in mind. I also make clear that we intend to engage fully with the inquiry, assist its work. However, that does not mean that we will do so passively or indeed uncritically where appropriate. And that leads me to a first submission, that indeed many of those that I represent are disappointed that 6 months on from the disaster, there is a lack of progress with the inquiry, particularly with the issue of disclosure. They are also concerned at the provisional nature of the timetable. Of course, we all recognise that that's a matter that needs to evolve. But today, we would certainly wish to come away from these hearings, or in the next few days perhaps, come away from these hearings, with a commitment to the fullest possible disclosure, to a commitment to an immediate start to the disclosure process to core participants, to a plan to provide us as soon as possible with a roadmap of what material the inquiry currently has, what it expects to receive in due course, and an idea of when it expects to receive that material, and therefore onwards to when it might be disclosed. We say, and we know that you recognise, that justice cannot be delivered to the victims of Grenfell by courier. It has to be with the involvement, it has to be achieved with the involvement of all, and in particular the victims. Most of the questions that are being posed to us at the moment, perfectly properly, about how witness statements are to be provided and when, about input into the instruction of experts, about timetable. We can only properly answer these questions once the disclosure process starts to roll. Let me just give a quick example. I'll come back to it with experts. Although very recently we've had the disclosure of the letters of instruction, we haven't had any of the material, or indeed knowledge of any of the material, that the experts have been provided with. In those circumstances, it's impossible for me to properly advise my clients or revert to the inquiry with proper comments about the instruction of experts. Before I come to disclosure in a little more detail, can I just turn to two topics which others have and will speak about, only because they are so important. I wanted to say that we fully endorse these submissions by Mr Mansfield, that the inquiry should sit with a panel. We fully understand that that's not in your gift, but we would seek that the inquiry is proactive on that issue. We hear what you have said this morning about a consultative group, and we will certainly go back and take instructions about that. But we would urge you strongly not to view a consultative group as being any substitution for a proper panel. They are two distinct and different issues. We also strongly support submissions regarding diversity that have been made and are going to be made in more detail by Ms Munro when I finish my submissions. Diversity has to be a central consideration at all stages of the inquiry. We say this, that if you were to sit with a panel which reflected the community which has been visited by this tragedy, then it would send a clear message that the inquiry understood the concerns of the community and the needs of diversity. We've made further written submissions about that, and I won't trespass much further on this subject. But in terms of diversity, we stress that our clients are all different. They are young and old, men and women. They're from diverse heritage. Most of my clients are Muslim, many of them from a North African heritage. They need an inquiry at all levels to understand their experience, so far as that is possible, and in order to give them the confidence that the inquiry understands diversity and that it'll be marked by action and hopefully the composition of the inquiry and not simply by words. Before I go to my main topic, again, one further matter, phases. We've listened carefully to what's been said by the others ahead of me in respect of phases. We don't have a fixed view on whether there should be two phases. We make the comment that time has rolled on, of course, for whatever reason. And we note the comments that have been very properly made about the equivalent of preventing further death recommendations that can be made. And we make the comment that were, for example, one of the expert reports to come back to you in a month or 6 weeks' time was to raise a matter which was of urgent concern, then of course you wouldn't wait until the end of phase 1 or phase 2 or phase whatever. You would report that immediately. So we doubt the efficacy of having two phases, but as I say, we don't have a strong view on that. Witness statements. We've listened carefully again to the need for witnesses to provide evidence about the 14th of June as soon as possible. We will assist in that process to the fullest extent possible. And we've estimated a timescale of 6 to 8 weeks, although that could be optimistic. It will depend, we would say, on the progress that is made with disclosure and how quickly that can be made. We are sure that the inquiry will recognise that our clients are not only important witnesses, but participants and victims, and must be treated as such. So the disclosure that is made cannot simply be tailored to the issues of them giving a witness statement, and in particular it can't be tailored to giving one part of their story the 14th of June. So I move on to disclosure. In general terms, the default position, we say, should be that call participants should see everything that the inquiry sees. We accept, of course, that there are categories of material which are out of scope. We accept that there are exceptions, narrow exceptions, we would say, where disclosure may not be appropriate, or indeed where delays to disclosure might be necessary, for example, for the purposes of the criminal investigations. But these exceptions, we say, should be considered by application as against the default position. They should not be assumed. We understand, for example, there may be applications to withhold or redact documents because of commercial sensitivities about contracts. These, of course, may be at the centre of parts of your inquiry, whether corners were cut because of financial considerations. We would hope that the inquiry would receive applications for such redaction or withholding of disclosure and would promulgate them to all of the CPs in terms that submissions may be made. As a part of process,
have you got a process in mind by which that could be done without disclosing that which ought not to be disclosed?
Well,
you might be prepared to discuss some.
Of course, we'll discuss that with your team, but those sorts of problems are not uncommon, and therefore categories of documents, for example, can be dealt with. In the example I give, I would venture that there would be no great difficulty in that process doing that in very short order. From our discussions, we don't think that the default position that we put forward is particularly controversial of full disclosure. We would hope not. If it is, we're happy to have it out further at a future hearing. But the process that Mr. Friedman has spoken to under Article 2, we would say compels the inquiry to take that as a default position in terms of a full, effective and independent investigation. Full disclosure not only to the inquiry but to the bereaved and survivors is fundamental to illuminating the facts and reaching judgments. And it's essential also to the confidence in the process by those affected and indeed the public more generally. Full disclosure also has a further role in confirming or allaying rumour and suspicion, whether well-based or false. And there are, of course, well-known cases where lack of disclosure has led to substantial miscarriages of justice. So to the nuts and bolts, if I may, of disclosure. There are very obviously two stages to disclosure, at least two stages to disclosure. Production to the inquiry and disclosure from the inquiry. And can I just deal with that in those two parts? We note that the inquiry has sent letters of request to various bodies. We've 5 particular points to make regarding production to the inquiries. We particularly refer to paragraphs 6 and onwards, and particularly 10 in our written submissions. But I want to start with a submission which we set out at paragraph 16, and this relates to candour. In our submission, the inquiry should seek position statements from all the public authorities and other organisations and companies who may have an involvement in the disaster. And we say that the inquiry should do so without delay. It should do so now. The experience has shown that such institutions and entities don't always act with candour. There has been much public debate following other high-profile inquiries and investigations concerning institutional defensiveness, what has been described as a culture of denial, There are, in fact, specific regulations dealing with the duty of candour in the healthcare sector for that very reason. Experience also shows that if there is candour at an early stage, the victims of such a traumatic disaster may not have to be subjected to such unnecessarily long proceedings. And the inquiry itself would be hugely assisted by being informed of areas of evidence which are less controversial than they might otherwise have been assumed to be. Let me develop this. The public authorities here, the other institutions, the companies involved, 6 months on from the disaster, will have gathered their own material, formed their views of what they understood happened, and they will know, to a significant degree, if there were failures on their part and what those failures were. Given the imperative that this inquiry comes as quickly as is possible to conclusions that will prevent further disaster and loss of life, and given the duty of candour on public officials and authorities which exists both at common law and under the Convention, we submit that such position statements setting out as full a statement of what they say happened and, crucially, what failures they accept on their behalf should be sought immediately. The position statements would greatly assist the inquiry in targeting further disclosure, honing expert evidence, tailoring the hearings to those areas that actually are in dispute or are unclear. Given the public interest in Grenfell, we would hope that none of the public officials or authorities who, of course, work for the public interest, or should do, or those organisations or companies who have undertaken management or work at public expense, would resist the provision of such position statements. But if they do resist such transparency and openness in the cause of giving the victims of Grenfell justice and assisting the inquiry, then, of course, let them explain why. We remind the inquiry and everybody else that in criminal matters, defendants are now required to give a statement setting out their case and what part of the prosecution case they take issue with. In civil proceedings, of course, the defence has been required for many years. What is, therefore, the imperative in inquisitorial proceedings? One would hope that position statements would be seen by all as a common sense and important aid through which to get to the truth as efficiently and as quickly as possible. 4 other quick points on the production to the inquiry. They've been dealt with in some way by Mr Millett this morning. Firstly, that producers of documents should be left in no doubt as to their duty of candour and frankness to the inquiry. They should be in no doubt that disclosure should be made where there's any doubt. Secondly, we would seek transparency about the process of production and the correspondence generated by it. We do seek disclosure of the letters of request for material and the responses to those letters of request. We don't, frankly, understand the reticence to be transparent about this part of the process. If a public authority or a company or anybody else is expressing doubt about their disclosure duties, or there are delays, then, with respect, we should know about it and we should be in a position to make submissions about it. Thirdly, we note that there is a suggestion from counsel to the inquiry that signed statements from chief officers or chief executives of each producer of documents may be required. We would invite you to consider making that a requirement in each case. Firstly, so that no one is actually singled out, but also so that nobody is missed. Lastly, in our written submissions, we've raised the issue of the need to gather original documents, and in particular take close attention to electronic documents. But I hear what Mr. Millett says about that, and I'll say no more about it. Finally, in terms of production, we say that the relationship between the police investigation and the inquiry is something that we've all acknowledged is being one of sensitivity and difficulty. We accept that. But beyond that acceptance, of course, the victims have a key interest in both the investigation and the inquiry. And although the concerns that are raised are very legitimate, they should not be allowed to unnecessarily impede the proper progress of the inquiry. And therefore, the relationship between the inquiry and the police investigation should acknowledge that the problems that are raised are, in fact, in practice, less than sometimes supposed. Mr. Mansfield has adverted to another inquest in which both of us were involved, where the relationship between the inquiry and the investigation managed to cut a middle line very carefully. So finally, in terms of disclosure to core participants, we've already emphasised the necessity of full disclosure. We note that that is acknowledged in the written material before today's hearing. However, we also note that there is reference to selective disclosure in some of those documents, and we respectfully submit that there is something of a mixed message here. We would invite you to make clear that the default position will be full disclosure. We say that disclosure to core participants should be of everything relevant or potentially relevant, apart from the small, narrow areas where there is a countervailing public interest. We say that the process that has worked elsewhere should be to recognise that disclosure has to be made on an ad hoc and somewhat chaotic way. I say that because producers of documents will produce those documents at different times, and that the only practical way of doing it and maintaining the progress of the inquiry, in our respectful submission, is to treat disclosure as it comes in, to triage it for relevance, and to take those narrow areas where disclosure can't be made out of it, and then to disclose it in tranches. And we would invite the inquiry to look carefully at doing that, and do that now. The idea that the inquiry needs to wait until it gets disclosure about particular parts of the list of issues before disclosure can be considered and then made to core participants is a process that we would say will not work, and more than that will lead to huge delays in terms of disclosure, and then an inability by any of the core participants, the individuals or the organisations, to be able to manage that disclosure and properly prepare and make proper submissions about experts, witness statements, hearings or whatever. And so we would urge you to rethink that and to make disclosure in tranches, as has been suggested. Further to the general disclosure process, we note that, of course, the inquiry has priorities. There's been discussion about Phase 1 and 14th of June. Apart from the general disclosure, we would invite the inquiry team to prioritise certain areas. There's been discussion about the witness statements that our clients are being asked to provide. We would urge the inquiry to take a wide view of the disclosure that's required for those witness statements. It simply isn't just that our clients need to see their police statements. There is a whole a number of different areas that they need to see. Some of our clients want to give statements which consider many different areas apart from the 14th of June, from which, of course, we will extract those relevant parts for the phase 1. But we can't take that statement without having a greater amount of disclosure. We note that there hasn't been any discussion this morning about video footage. We would invite the inquiry to make available to core participants all of the video footage that's available of the fire and its immediate aftermath, and all of the 999 calls, as well as the other matters Mr. Freedman in particular listed, which are appended to his submissions, and to those which are appended to the Fire Brigades Union submissions, which have been very helpful. It is in our submission essential that we have such material so that we know what questions we should be asking of our clients to elicit the relevant material. We also wish to have the housing and repair files, which may well bring to the fore complaints that have been made by our clients about safety issues and the such like. So the fuller the disclosure that's made at this juncture, the better the statements that we provide to the inquiry, the more useful they will be. Those are our submissions. Beyond those, we endorse what's been said about experts with the caveats that I've spoken to already. And we note you will be addressed further about the venue for hearings, and we would like to put on record that our view is that the venue should be at a location closer to where the disaster occurred. I don't know whether there's anything I can assist with further than that.
I think not at the moment, thank you, but that's certainly been very useful and very helpful. Thank you.
Thank you.
And very good timing, if I may say so. Before we all rise for some lunch, Ms. Murphy, you wanted to be included in this list of those who are going to address me.